start recording now, but we will have a Q&A at the end of the session tonight. And so jot down things as they come to you, because we will have a time for us to ask specific questions, and we want to make sure that everyone's questions are answered before we log off for this evening. So I just want to get started. I want to share with you our guest expert. And again, for those of you who don't know, I typically hold a live training monthly. And the monthly trainings are specifically targeted to those who are in my Facebook community, the Master Playbook community. But because this topic was so compelling, because it's a topic that's rarely discussed, I opened it up to the public, and because I think it's so important, especially in these times where we're dealing with this pandemic and you're seeing a lot of people unexpectedly pass away. I don't want my network, I don't want the people who follow the Master Playbook to think that GoFundMe is an estate plan, okay? I want you guys to be well educated and better equipped to put the appropriate things in place so we can build wealth, right? Not only build wealth, but extend our wealth beyond our lifetime. And so we're going to talk about some of those things today, all right? So let's introduce our special guest. And so Shannon, can you for just 1 second stop sharing your screen so people can see your face? We have attorney Shannon Wilson with us this evening. She is the founding attorney of Legacy Legal, where her expertise is really centered around estate planning and creating legacies one family at a time. Now, she started her legal career in the state of Tennessee, where she investigated employment and housing discrimination claims, and then she transitioned her practice to the U.S. federal government. And so since she has had a lot of experience, and now she is operating her own firm, again, Legacy Legal, she took all of her passion, all of her knowledge, all of her experience, and she is dedicated and passionate about helping individuals, about helping families, and really helping us lay the foundation so that we are protected. And we want to dispel a lot of the myths tonight, right? Because you don't have to be rich, you don't have to be wealthy, you don't have to be a millionaire in order to have an estate plan. And so we're going to talk about those things this evening. So again, pull out your pen, pull out your paper. I am so happy to have you, Shannon. So welcome, welcome, welcome.
Thank you, Holly. And I love how you started off by saying you equip parents. And it took me back to when we met a couple months ago, and it was like we clicked instantly. Yes, that's what we need to do. We need more of that. And so like Holly said, everyone out there, I am passionate about what I do. I often tell people I do what I love, and I love what I do. So getting into estate planning was just it was honestly a fluke, but it couldn't have worked out better in my favor. And I am always honored when I help people, because helping individuals thereby helps the communities, which helps all of us. And we just don't do better until we know better. And I make it my mission to ensure that people know better so that we can do better. And
Absolutely.
So just wanted to come to you all tonight. Thank you, Holly, for inviting me to this. And just want to share some tidbits of information with everybody about what estate planning is, what all is involved, and why it is so, so important, critically important, especially now when we are in the midst of a pandemic, especially now when our inheritances are being impacted, not only financially, but physically. You know, many times people think that they have to have so much in order to engage in estate planning. And like Holly said, that could not be further from the truth. It is a myth that we must dispel. And there are certain things involved in everyone's life that involves estate planning. You know, I'm an attorney, and quite frankly, I really don't like math, which is why I lean heavily on people like Holly, because I don't do math very well. but there are two statistics that I do know, and I know them like the back of my hand. And so one of those is what happens if I should become incapacitated. And the statistic that goes along with that is 30%. 30% of people will become in some way, shape, form, or fashion incapacitated during their lifetime. To me, that's a pretty staggering statistic. That means about 1 in 3 of us. And so every good estate plan should take that into consideration. The other statistic that I know, and all of you probably know too, you just probably haven't thought about it like this, but that's 100% of us are going to die. All right, 100%. There's no way around it. We just don't know the day, we don't know the hour. And so every quality estate plan should also take into consideration what happens when I die. And the third thing that every estate plan should take into consideration, and probably this is the most passionate part for me, is what do I want my legacy to look like? That's why I named my firm Legacy Legal. You know, so many times we, especially women, especially parents, we spend our lifetime giving to others. We spend the bulk of our time at work for somebody else, many times. We spend a lot of time supporting our children in everything that they do, raising them through life, all of the ups and downs, the wins and loses, everything. And we often neglect to think about what we ourselves want that to look like. And during this pandemic, I have 2 sons, 2 teenagers, and they are like night and day. When I promise you, when I say they're like night and day, I think they do it intentionally. They disagree on everything, right? But one of them has enjoyed putting puzzles together with me. And it came to me one day that we were sitting there, and I had really kind of thought about it a little bit, but this one particular day, we're sitting there, we were getting close to the end of a puzzle, and I looked at all the pieces that were left, and I looked at the box again, looking at the picture, and I thought, what do I want my legacy to look like? If I put my plan together, then I'm essentially giving my loved ones, giving my family, my friends, my coworkers, everyone that would have a stake in it, I'm giving them those puzzle pieces in a box with the picture. If I don't put all of those puzzle pieces in a box with the picture, then they are left to their own devices. And I assure you, when left to their own devices, what I want my legacy to look like is not going to look like the puzzle that they put together if I don't give them the box. So estate planning answers the question of what do I want my legacy to look like? And a proper estate plan, and this is a quote I love, a proper estate plan will include both lifetime and at death planning components to account for 1, the possibility of incapacity, and 2, the certainty of death. So you may be thinking, well, how do I do that? How do I create my legacy? There's one word: you have to plan. You can't just do it by the seat of your pants. It's not a last minute thing. You have to plan. And in that planning, you must be strategic about what you do. All right. This is where people like Holly come in. We help you work that plan. What do you want your puzzle to look like? What pieces do you have that go into your legacy puzzle? And so planning is paramount. You know, most people plan for what they're going to do next week. People plan for what they're going to eat for lunch. People plan for what they're going to wear tomorrow. People plan for everything. People plan for driving around the corner. Do I need gas? Like, we plan for everything. And most of those things that we plan for in the big scheme of things are really not that important. So why not take time, think about your legacy, put together that strategic plan that's going to help you leave this earth with the legacy intact that you would like to have intact. So as we go through this, and I know Holly said we are absolutely going to have a Q&A at the end, but if you have any burning questions, type them in the chat box. We will get to them at the end.
Yes, absolutely.
Right. So how do I create my legacy? Essentially, estate planning is an area of the law, and it is the only area of the law that everybody will need. Why do I say that? Because everybody is going to pass away. So it's really the only area of the law that everyone will need at some point. And legally, there are documents that must be in place to help you facilitate that plan, that strategic plan that you have in mind for what you want your legacy to look like. So as we go through tonight, and we're going to have a a couple of scenarios, 5 scenarios that take people, one person through life. And we're going to talk about the different ages and stages at each portion of life. And we're going to talk about how estate planning works. So as you're taking notes, as you're thinking about these, think about these documents that will facilitate that plan. So what are those documents? The main documents. The first one I like to call the blank check document, because it is the document that says if I'm unable or unwilling to handle my finances or my legal issues, this is the person I trust to do so for me. What does that look like and what is it called? It's called a power of attorney. So that's the first document that everyone should have in place from the time they turn 18 years old. Talk about dispelling myths. Most 18-year-olds really don't have anything. Most 18-year-olds are still on mom and dad's bankroll, in mom and dad's pocket, and everything else. However, and this is important, especially right now with people going back to school, 18 to 24-year-olds, yeah, they're still on insurance, they're still in your pockets. However, if something happens to them legally or financially, mom and dad or whoever the guardian are, they will not be able to take legal action in their place without this document in place. So that document is a power of attorney. The second document that everyone should have in place, and I call this one the God proxy, because 1, we pray that nothing will happen to us, and 2, when something happens to us, many times we are superstitious and say, well, if that's what God's plan is, then that's how it's going to work. So the second document that everyone should have is a healthcare record. And many of you may have heard about this here recently with COVID. The healthcare record is a document, a legal document, in which you name somebody to make your medical decisions for you if you're unable to make them for yourself. Okay, nobody likes to think about that unfortunate event where you're laying somewhere and can't speak for yourself medically. Well, it would be even more unfortunate if nobody else has been named to speak for you and make those your advice and your decisions known. So a healthcare record. And so there's 4 parts to it. The first part is the proxy, where you name somebody. The second part is an advance directive. Many people know of it as a living will. This is where you give that proxy that you've named instructions. This is where you say things like, I want a do not resuscitate. Or you say things like, no matter what, I don't want a ventilator. Or if something happens to me, I don't want to be on life support for more than 3 weeks. This is where you make all those wishes known. The third part of the document is what I call an extended HIPAA. In HIPAA, like most of you have been to the doctor and they have you check the box saying you got the HIPAA policies. And quite frankly, most of the time they don't even give you the policies. I'm always that person that says, oh, no, I'm not checking this box because you didn't give me the policies, right? So the HIPAA policies are part of it. And in estate planning, there's a portion where you can name not just somebody where they can leave a phone message, but you can name 2, 3, 10 people that you would actually grant access to your medical records for. So that's the second document, is the healthcare record. The third document is your puzzle box and that bonus picture on the outside. And this is the document called your last will and testament. If a person passes away without a last will and testament, the government gets to decide what happens with all of your puzzle pieces. The government gets to decide what happens with all of your stuff. And I use that lightly because we all have different layers and levels of stuff, right? And so having that last will and testament in place is key to estate planning, because most people work too hard and have gained too many assets, even if they only have $3. Those are their $3 to say what they want to happen with it. I don't really want the state of Georgia stepping in and saying, aha, you didn't have a will in place, I get those $3. If I want it to go to A, B, and C, that's where I want it to go. So having that document in place is paramount. And then there's a fourth document that many people, especially people that have minor children, especially people who are business owners, and especially people who own property, even if it still has a mortgage on it, that they should have in place, and that's called a trust. So many times we've heard about trusts in the news and we think it's only for the rich and wealthy. Well, that's not true. Everyday Joes like you and I can have a trust in place. as well as anyone else can. And it is a private document, unlike a will, because anyone and everyone can go to the probate court and get a copy of a will. Face it, people are nosy. And if they think you have something or they want to know what you have, they're going to go try to find it. A trust, they can't get that information, but they can in a will. So it's key to have both a will in place that says I leave everything in the trust, and then you leave everything in the trust with specific instructions as to how to direct those. So I think, Holly, I want to pause right there because I saw a hand raised. Are we going to answer questions now? I'm not able to see the chat room to see if the questions are popping up.
Sure. I don't have any questions currently in the chat.
Okay.
Yeah.
All right. Well, I will just keep going. All right. So for purposes of the discussion this evening, and we really kind of wanted to make this interactive, so we are starting with a young woman named Sue, and we are going to work all the way through the various ages and stages of Sue's life. I'm sure that everyone on this call will be able to relate to one, if not more than one, of the scenarios that Sue is in. So, Holly, you want to read the first scenario?
Yeah, absolutely. So our first scenario is we want you to meet Sue, right? So Sue is a young professional. In this example, she's a woman, but it could be a man. She has worked really hard. She has created what she calls the perfect balance in her life. She loves her job. She spends lots of time with her friends, her family. She's very active with her hobbies, lots of activities, and Sue is actively dating. But listen, she is not overly concerned with marriage or a serious relationship. So in this scenario, Shannon, what should she be thinking about when it comes to estate planning?
All right, so in this scenario, Sue, whether Sue is male or female, should have the three basics that I talked about when it comes to estate planning. At this point in her life, she is an adult, so she should have in place a power of attorney. I use a durable power of attorney because that one becomes effective immediately upon signing. You don't have to wait for some incapacity to occur. So she should have that power of attorney in place that says, if I, Sue, am unable to handle my finances, if I, Sue, am unable to handle my legal issues, this is the person that I named to do so for me. She should also have a successor or a backup to that person named. She should also, second, have in place that healthcare record that says, you know, what happens one day when Sue, all of her hard work and she's in an accident. Right? I like to use this analogy, especially here in Metro Atlanta, because it always makes people go, oh. So the analogy is Sue is walking across Peachtree Street and gets hit by a MARTA bus. And she wakes up 6 months later at Grady Hospital. Okay, what has happened during that 6 months? Nothing if she does not have the documents in place to say, all right, this is the person that can make sure my rent or my mortgage is paid. This is the person that can make sure my lights don't get cut off. She has to have all that in place. So how does she do that? The first one is through that power of attorney. The second one, remember I said she wakes up at Grady Hospital, she's been in a coma for 6 months. Who's been making those medical decisions for her during that time? Nobody, unless she has that healthcare record in place that says, this is the person and the successor to that person that I named to make my medical decisions known for me if I'm unable to speak for myself. The third document that she should have in place is that last will and testament. In this example, fortunately, Sue woke up and she recovered, as we'll soon find out because she goes on through our scenarios. However, if she hadn't and she had passed away, she needs to have that last will and testament in place that says, this is what all I own at my death. These are my assets. This is what my estate looks like. These are my physical assets. These are my financial assets. And these are my real property assets. And this is who I want to go about the business of distributing them. And this is how and to whom. So your last will and testament is your opportunity to lay out what you want to happen with all of your assets at death. So Sue, young professional woman, unmarried, no children, career-minded, still needs to have in place at least those three main documents: the power of attorney, the healthcare directive, and that last will and testament.
That's great. Now, Shannon, would those 3 documents also be needed for someone who never married, who never has kids or whatever? Are those 3 documents still the ones that they need?
Everyone needs those 3 documents from the time they turn 18. Now, estate planning is not a one and done thing. And I often tell people we revisit. Matter of fact, my clients, I tell them every year, we're going to revisit, make sure nothing has changed, or see if anything has changed that impacts your estate plan. I often tell people that when the 4 Ds, and those are, if you want to write these down, divorce, disqualification, meaning you had a job yesterday and now you no longer work there, so you're disqualified from that health plan. So divorce, disqualification, disability, or death. When the 4 Ds collide with the 5 Fs, and the 5 Fs are faith, family, finances, fitness, and fun. Anytime those 4 Ds and those 5 Fs do this and collide, that is a great opportunity to revisit your estate plan and see what has changed.
I love that.
Thanks.
All right. You want to go to the next scenario?
Yeah, let's go to Sue's next age and stage in life.
Okay, so now we're going to fast forward about 8 years. And Sue, so you just got to flip the switch, change the thing.
Mm-hmm.
But yes, so we're going to fast forward about 8 years. Sue has met the love of her life. His name is Sam. Sue and Sam, how cute is that? And now they've been married for 5 years now. So they both work professionally. They have a small multi-level marketing business on the side to generate some additional income. They have now purchased a home. They purchased a home last year. They got a 30-year mortgage on that home. But listen, they are comfortable. They're comfortable with their finances. They're happy in their personal state, and they want to expand their family. So here comes their bouncing baby boy, Sammy, Sam Jr. Yep. And he is born 9 months later. So with all of this change and growth and prosperity living that they're in right now, what would you recommend now for this family?
All right, so perfect example of those 4 Ds colliding with the 5 Fs, right? You know, everything has changed for Sue from 8 years ago. You know, she's got a husband now. She has multiple streams of income now. She has a home now, and she has a baby. So how does the estate plan change? The bones of it does not change. Remember, she already had in place those 3 main documents. She already had the power of attorney. She already had the healthcare directive. She already had the last will and testament. So now it's a matter of updating her plan. Remember, in the beginning, we said planning and strategically so. So now her strategy has changed. She's no longer single Sue. Now she is Sue and Sam and Sammy. So her power of attorney should probably be changed. Maybe now she might want to name Sam as her power of attorney, whereas before maybe she named her sister or a friend. Her healthcare directive is now going to change. Maybe now that she has a husband and children, before she might have wanted to do not resuscitate no matter what. Now she might want to fight for life. So now she's going to have to change or edit that healthcare record. And in that editing, maybe now she wants to perhaps name Sam as one of those people who can have access to her medical records. Maybe not. You know, there's nothing that says that spouses must name one another on any of these things. As a matter of fact, I always find it quite comical when spouses come to me for their estate planning and they're sitting there and one of them kind of shyly says, do I have to name my husband or do I have to name my wife? No, there's nothing that says you must do that, okay? And it's always really funny when they're like, oh, you wouldn't name me. Well, honey, you're so sensitive. If I said I wanted to do not resuscitate, you wouldn't want to do it. So I would not want to put you in that situation. You know,
Gotta know your people. Gotta know your people.
You gotta know your people, and it's a conversation. You know, it's conversation that unfortunately we don't have until it's too late. because we don't engage in this strategic planning. So having those conversations early and having them often is key to estate planning. So Sue is now Sam and Sue and Sammy, so she should revisit her plan, looking at her power of attorney, looking at her healthcare directive, probably adjusting her last will and testament. I would say that before marriage and before child, she may have left everything that she had to somebody else. Maybe she didn't have much, but now she's got multiple streams of income. She's got this mortgage, or they have this mortgage. So now they may want to consider adding a trust to their plan. Okay, another thing that I'm going to rewind 5 years. It says they've been married 5 years. So another thing that they may have considered is a prenuptial agreement. I know that always makes people say, oh, I would never do that. However, when you have finances, when you have assets, when you have friends and family that you would like to leave a legacy for, and you want to leave that legacy regardless of that intended spouse, then you should have a prenup in place. Because what happens when that marriage breaks up and now that what you have earned together is marital property, but what about what you had going into that marriage? You don't necessarily want your new spouse to get everything. And we're going to talk a little bit about that later. So they should have had a prenup in place potentially. Now they should both, Sue should make sure Sam has his estate plan in place. Make sure they're naming one another if that's what they want to do, not naming one another if they don't. Here in Georgia, Georgia's the only state where you can disinherit your spouse. I repeat, Georgia is the only state where you can disinherit your spouse. What does that mean? That means if I have a spouse and I don't want them to get anything, I have to put that in my estate plan. I have to put that in my documents. If I don't have those documents in place, the spouse is going to be automatically entitled to a large, probably, portion of my estate. Depends on how many children there are and everything else. So again, Georgia's the only place where you can disinherit your spouse. How do you do that? You have to have the plan in place. All right, so they should both have their plans in place, at least their basic plan. And now they should probably think about having a trust in place to leave that legacy of that home that they just purchased for Sammy and any other children that come in the future, or for their families, so that that home does not become heir property. And heir property is property that has a deed attached to it, but the person named on the deed is deceased. Okay, so now who owns that home? Nobody. Heir is H-E-I-R, not A-I-R, right? So it becomes heir property when you have a deed that is not attached to a living person. So when you have a trust in place, we take individual names off of the deed and put the trust's name on the deed. That way that property can go on forever and ever. Well, not literally, but it can go on for generations. This is how people create generational wealth. The property can go on for generations without having to redeed it, or without having to go through the probate process, which is the process, the court process that one has to go through at death. So, and they should also maybe think about having some other financial tools in place now that they have Sammy. You know, they have their multi-level marketing, they both have their professional jobs, but they may also want to consider some life insurance and some long-term care insurance, because if something happens to them, Sammy is going to need to be taken care of for the rest of his life, or at least until he becomes an adult. So having those tools that work in conjunction with estate planning in place for the next years of their lives. They're living in that blissful honeymoon period right now, but they should not be ignoring their estate planning.
Yes, absolutely. Okay, so insurance absolutely is part of this. Disability insurance, you heard the statistic earlier, about 30% become incapacitated, which just basically means that you're not operating at your normal capacity, right? So, all right, let's fast forward. So we are going to continue with Sue, Sammy, and Sam, and we're fast forwarding 12 years. So Sue and Sam, they have both been promoted with their jobs. So now they're generating higher income, higher salaries. And in addition, they're on the side business, their MLM business. It's thriving. You know, they've added members to their team. They're generating more income than anticipated. And Sammy has made it through his infant years, his toddler years, and his elementary years, right? However, he has struggled academically and socially. And what they discovered is he's been diagnosed with a rare developmental disorder, okay? So becoming increasingly tired of school administration, having grown their business, Sue has decided she's going to take this opportunity now to quit her job and to work the business full time. And so a lot of people do this, right? And then shortly thereafter, Sam joins the club. So Sam is like, okay, Sue is thriving. We can do this. I'm going to join her. And he now leaves his job. So now they may not have steady income. They may have, you know, high income one month, low income the next, just depending on their business, right? But they also left those benefits behind that those full-time jobs were providing for them. And now we got a surprise. Somebody pregnant. You know, when things are going well, we start multiplying.
That's right. That's what happens. I know we've all seen it, heard it. Maybe some of you have personally experienced this, right? So
yes.
Things have changed now for Sue and Sam and Sammy and, ooh, baby to come. So now what do they do with regard to their estate planning? So I want to take these off one bite at a time. So let's talk about first, okay, Sammy is now a 12-year-old who has special needs. So that is going to take his life and change it, right? And by changing his life, making him now a child that has special needs, this means Sam and Sue have to revisit their financial plan. They have to revisit their estate plan. Because what this means now is when Sammy turns 18 in, 6 years? I told y'all I'm horrible at math, but that's 6 years from now. When Sammy turns 18, he is not going to be like most 18-year-olds who they can say, okay, bye-bye. We've done our job. There's still going to have to be some care given to him. So what they can do at this point is if they put in place that joint trust in the scenario 2, or age and stage 2, because that would be what they would have in place, would be a joint trust. They would each have their powers of attorney, their healthcare directives, and their last will and testaments, but jointly they would have a trust. And that trust could address what happens in remarriage. That trust could address what happens when the first of them passes away. You can address all kinds of things in that trust. But now they may want to add to that or add a portion to that trust that's called a special needs trust. And there are certain funds that Sammy may be governmental funds that Sammy may be entitled to and benefits. So they have to be careful about planning for his financial security because they don't want him to have too many assets that will disqualify him from any government benefits that he would otherwise be entitled to. So that's the first part I want to talk about. The second part, now we've had a collision between the 4 Ds and the 5 Fs because they both left their jobs. Remember I talked about disqualification? So now those life insurance policies that they probably had under their employers, the health benefits that they had, all of those things are now gone. Again, they have to revisit their estate plan and look and see, okay, how are we going to manage this? How are we going to create a plan that's going to be a safety net for us and allow us to also leave a legacy? The third part of it is now they don't have a steady income. And now, whereas they were kind of playing with that MLM income and it was their, what is it that people say, their, not their side gig, but something like that.
Side hustle.
Their side hustle, thank you. Thank you, that's their side hustle and their fun money, right? Well, now that's their everyday living money, right? And so things have changed. So now they have to strategically plan for that. You know, before, yeah, they were working every day, they were paying the bills, they were using that as fun money, having those vacations or, you know, the extra shoes and clothes and other things that people spend money on, right? That Holly works with you to make sure that you are able to do that and do it comfortably without being under the house that you're paying for, right? So ensuring that all of those things are now in place, especially with regard to how they set up that estate plan, is key. You know, before maybe they set up that trust and they wanted to leave the house to so-and-so, or they wanted to turn it into an income producing property, a rental property. Well, now that money that they're spending on the mortgage is crucial because they don't have that side hustle. They don't have that added income. So maybe now they're sinking everything into that. So that part of their estate is more critical. That part of their estate is also more critical because now they have a child with special needs that's going to end up being an adult with special needs. And oh, by the way, new baby on the way, that's an added income. That's added to perhaps the stress of their lives. It adds everything. It doubles everything, right? So now they're going to have to think about, okay, before we might have wanted to leave everything to Sammy, well, now we're going to have another one on the way, and how do we want to divide that? So many times people approach estate planning, especially people with more than one child, and they approach it from this standpoint. Oh, I just want to do everything evenly. I don't want anyone to feel different, or people do that, right? And a certain part of me agrees with that. However, the estate planning attorney in me says, you don't have to do that, right? Especially when you have children who are like mine, night and day, and you know, unlike mine, one of them's never going to do right, okay? And the other one's always going to do right. That one who's never doing right, they know that they're that child. They know it. They've grown up. It's always been that case. And so their feelings will probably be hurt when you don't leave anything to them. However, your bank, their bank, everyone else around them will appreciate it if you plan your estate in such a way to make it equitable, but not even. And so taking those things into consideration is really key, especially at this age and stage for Sue and Sam. I would hate for them to be in a predicament where they have planned, but then circumstances cause them to have a GoFundMe if something happens. Okay? Estate planning is not planning to have a GoFundMe. Okay? That's just like saying I'm working, and I plan to file bankruptcy so that I can get ahead. That's not how it works. Okay?
That's right.
And unfortunately, so many times we don't have those critical conversations, again, like I was saying, and we don't plan properly. So now everything has changed for Sue, Sam, and Sammy. Not everything, but many things in their life have changed, and they're going to have to revisit their plan.
Yes, so parents, you have permission now. You do not have to do it evenly.
No.
The estate plan is not a short-sighted plan. You got to think long-term. Who to be the most responsible dependent that's going to take it and extend it beyond even their lifetime, their generation. So it's the perfect time to think long term and to put the things that you've accumulated over time in the right hands with the right decision makers. This is
right. Put them in place properly. And there's nothing wrong with, this is another beautiful thing about estate planning, especially when using a trust. You can say things like, I leave my home to my children to turn into an income producing property. And you can say things like, if one of my children is to predecease me, that means they die before you, then their portion goes to their children. Or you can say things like, if one of them predeceases me, then their portion goes to their siblings. So you are driving that. If you don't put it in place, then you risk the state saying, well, now everything goes to these 3 kids when, you know, this one right here in the middle was never any good, but they have 4 grandkids that you really want to take care of. Well, you may not have that opportunity to do that if you don't have the documents in place.
absolutely. And so now we're going to take this even further. So in stage 4, Sammy's going to grow up. Sammy is now 22 and his sister Sarah is now 10. Now, Sarah is all over TikTok. She's a thriving socialite. She loves being a preteen, but she also feels as if her parents devote all of their time and energy to Sammy, which is probably true. and to the business, right? They have spent the last 2 decades focused on Sammy. And so their finances are now questionable, meaning the business has its ebbs and flows. They've managed to pay off their mortgage, which is great, but every penny otherwise goes to the high cost of Sammy's care. And now, because of this stress, this strain, they are starting to grow apart. Sue and Sammy, they've started to grow apart. And here we are hitting that D word. Unable to handle the stress, their relationship turns volatile. And now Sammy and Sue decide to divorce. So now what is important to pull out here?
So now we are at that other age and stage. You know, Sammy is 22. That means he's an adult now. That means he can, if he were functional, he could make his own decisions with regard to finances, with regard to healthcare, with regard to everything. However, remember, he had that developmental disability, and so he's unable to do that. This means now Sam and Sue have to shift their focus from being his parents, and now they are his guardians or conservators, both probably. So a guardian is somebody who is put in charge of the finances for an adult and the legal issues. And they have to actually petition the court. They have to ask for permission to become his guardians, even though they're his parents. When you reach 18, now you have to ask the court for permission to do that. They also have to ask the court for permission to become his conservators of his health, his medical decisions, because again, he's developmentally disabled and unable to make his own medical decisions. So again, they're going to have to, at the time he's 18, they can apply for that as early as 17 and a half. Sarah, who's 10, Holly's right, she's probably all over TikTok and doing everything else right now, right? But she's still struggling. So Sarah needs some attention too, but how do they plan for that? They have a preteen who's eventually probably going to grow up and maybe go to college. There's nothing that says Sammy's not going to college, but if they haven't planned accordingly, they may not be able to pay for it for either one of them. So college planning is key, especially at these ages and stages for the two of them. Remember I talked about the 4 Ds and the 5 Fs colliding. This is a collision that is staring us in the face. Now they're divorced. What happens? Okay, well, first, if they did not have that prenup that I talked about, and those are, you know, conversations that have to be had. They're not for everybody. Some people would run away and never do it. Some people just would ignore the conversation. But now here we are in this scenario where if they didn't have that prenup in place, now they are going through the divorce process, and everything that they have is considered marital property. And so they're going to have to go through the division of assets. Does that include the house and the business and everything that they have? Absolutely. So now that D, divorce, is colliding with faith, family, finances, fitness, and fun. So they are going to both be probably starting all over again, back where they were when they first married, right? And so that's going to impact their estate plan. Divorce. Holly said that their relationship has now become volatile. You know, I would venture to guess that neither one of them want the other one as their healthcare power anymore. So make those changes. This is the time where you have to make those changes. If they were listed on life insurance policies, make that change. You don't want that ex-spouse being the beneficiary on a life insurance policy at any age or stage. So though, again, it's a time to revisit your estate plan. Making sure that the businesses are properly structured. So in their previous scenario estate planning, they probably should have taken into consideration some succession planning for the business. And what that means is, what is our plan if we are unable to work this business either together or solely? So having a succession plan in place for that business. And oh, by the way, I'm not a tax accountant, but I do know this, and I advise business owners of this all the time, including your business in your estate plan, especially as a solo business owner. Now you have a taxable write-off expense because your business expense is your estate plan. So not only is it personal, but it's business. When they're tied together, now you have a write-off. What does that mean? You let the business pay for your estate plan. All right. So having those having those in place is key. Another thing, they have managed to pay off their mortgage. So now they own this property free and clear, no mortgage. So before, if it was in a revocable trust, which is one that can be changed over time, which is one that you can go in and make changes and edits and move things and sell things and all of that. Well, now they've paid for it. They don't have that mortgage anymore. So now that property could possibly go into an irrevocable trust, long-term wealth, turn it into a rental property that anyone can live in, and maybe Sammy and Sarah split the proceeds from that income. But again, we have to be careful that Sammy doesn't get too much and disqualify him from those benefits that he's otherwise entitled to. So again, we're at another collision point in their ages and stages of life. Sammy is 22. Let's just say that Sam and Sue are in their late 40s. So now collision course, rebuilding, reinvestigating, revisiting that estate plan to make sure that their individual goals as well as their collective goals are still being met by their plan. Remember, individually, they have their powers of attorney, they have their medical directives, they have their last will and testament, but they have that joint trust. So whatever happens in that divorce is going to impact this joint trust, and how this trust was set up in the first can be addressed in the divorce. Okay, there's you can put a remarriage clause in there that says, if A and B are married and C comes in and marries the one from the divorce, you don't want C's family getting everything that you've worked for in this trust in the first place. So having that clause in there is key. And addressing how the division of property are going to take place is absolutely going to impact their plan. And starting over is never fun, but when you have a plan in place, again, I can't say it enough, when you have a plan in place that helps you tackle it strategically, especially not only for their benefit, but for Sarah and Sammy's benefit down the road.
This is so good, such good information. And so now we're going to move along to the 5th stage. This is our final stage. So if you have any burning questions, you can start pulling those together, pulling your thoughts together. But now Sammy is now 40 years old. Sammy is grown, but he still needs help every day living. And listen, he always will, but he's had a series of girlfriends. He's just not married any of them. So Sammy not doing too bad. Now, Sarah, on the other hand, Sarah is now 28. She's happily married to Tom. They got out those S's, and now they have 2 children. But unfortunately, Sue, the wife, the ex-wife in this scenario, developed a terminal illness, and she passed away earlier this year. Now, when Sue passed away, Sam found him a hot girl named Ellen. He remarried Ellen, and Ellen had 5 children. Ellen's children are 35, 30, 26, 17, and 15. She is also blessed with 3 grandchildren. So Ellen's minor children, the 17 and the 15-year-old, and 2 of her grandchildren live now with her and Sam in the house that he got after he and Sue divorced. And it's that same house that Sammy and Sarah grew up in. So his family has grown exponentially. It's almost like he's starting over, taking over, and raising Ellen's minor kids. So I'm curious to know what now are the things that Sam and Sammy and even Sarah may need to be thinking about during this phase of life.
Yeah, so I know this sounds like a soap opera. It sounds like an episode of anything that you would watch on television. And it's really kind of funny because TV shows just don't pop out of the air. The writers are inspired by things that they see and things that happen around them, right? And so one thing I want to first talk about is Sue and the fact that she has passed away. So now what does that mean? That means that Sammy and Sarah probably now have to go through the probate process to distribute her assets, and whatever assets those are that she has since divorcing from Sam. We now know that Sam got the house, so she doesn't have to worry about that, right? But they have to go through the process of distributing her assets. Fortunately, if the trust that they had in place addressed it, then the probate process is going to be very limited, because now they just have to go to the court with her will, which she had in place, right? With her certificate of death, and say, may we, if they are named as the executors, may we go about the process of distributing her assets? Well, she's going to have been smart, because she's going to have a pour over will that says, I'll leave everything in the trust. So that process is going to be relatively easy for them. Another portion of that is, depending on what Sue's wishes were with regard to her terminal illness, they may have been the ones there discussing her treatment. And so having that in place, because when you have an illness, it's hard enough to deal with that illness as it is right then and there. But if you have to complicate it by now having to make decisions about it, that just makes it more difficult on everybody. The other portion of that is, death comes with it grieving. And the grieving process is traumatic enough, but if you can lessen that grieving process by having your plan in place for your loved ones, so that they can simply grieve and they don't have to worry about the business and the ins and outs of the death, then that is a critical part of estate planning. The second part of this, Sammy's 40 years old. He's had girlfriends on top of girlfriends. That can potentially cause alarm, because now Sarah, remember Sarah was already kind of suspect about her brother and him getting all the attention, right? So now she's like, well, mom died and dad now has this new wife and an entirely new family. Where's that going to leave me? And am I going to have to take care of my brother? I've heard the story. That's just how people think. So Sammy and Sarah are now at a critical juncture as well. They should probably at this point both have their estate plans in place. Sammy probably is not competent to do his own estate plan, but hopefully Sue and Sam, as his guardians, have set up some sort of trust that will carry forward from him. Sarah should have her estate plan in place with her husband Tom and her 2 new children, right? Now let's talk about Ellen. And Ellen has swept in here and married Sam and moved her entire family into his house, right? Well, now Sam is functioning at what I call 2 ends of the estate planning candle, right? Because Sam is approaching his 70s, 80s, right? So he's probably thinking about that 100% death about now, but he also has these grandchildren in his house, and we're going to say that they're probably under the age of 10. So he's like burning the estate planning candle on both ends. How do I plan for this as well as this? So he's going to have to really do some revisiting of his documents. He's also going to have to completely think about that trust. So remember, Sam and Sue put that trust in place originally for their family, their offspring, their heirs, their legacy, right? They still have those heirs. They still have that legacy. That's Sammy and Sarah. But now Ellen has swooped in, and let's say something happens to Sam. Do you think Sue would want Ellen getting that entire trust and everything that was in it that they built for Sammy and Sarah? I dare say no. She would not, right? So however that trust was established needs to be revisited if it was established in such a way that they can. Sometimes the way the trust is set up, once the first of them passes away, then it becomes irrevocable and the second one can't do anything. But if that clause is not in there and the first passes away, now the second can do whatever they want to with it. That's not always the decidable factor that people would want. And so revisiting at that point, revisiting the finances. Now he's got this home that I guarantee you Sarah has her eye on. And Sarah does not want Ellen and her grandchildren getting that home that she grew up in, however happy she was, right? You know, when she was 10 doing that TikTok, now that she's 28, she's thinking about, oh, I miss that bedroom. right? Or whatever the case may be. So having provisions in the trust, or maybe now Sam has a new trust, and maybe Sarah has a prenup with Tom that says, you know, whatever I get from my mom and dad's trust is mine, whether you leave me or not, it's mine, right? And so having all of those things in play, having something in play to care for Sammy. Remember, he may be 40 and he may have girlfriends, but again, what if he marries one of those girlfriends and now he comes back and says, well, Dad, I want the house. And Ellen's sitting there going, you don't get the house. I'm married to him now. Y'all know how drama works. Y'all know how family dynamics work. You know, no two families are the same. No two dynamics are the same. You know, siblings can be one way one day, another way the next. It depends on how the paperwork flies, right? And it's unfortunate that unless you put it in place and unless you put it in writing that says what happens, then you risk the court stepping in and making that decision for you. So at this age and stage in life, Sam is revisiting everything. Sammy is comfortable and living his life, not really realizing that he could be coming into some inheritance. Sarah is good, but she's got her eye on that inheritance. And hopefully they set up everything accordingly for Sue's passing.
Yes, and so we do have a couple of questions just going back to one of the scenarios. So the scenario when Sam and Sue first got married, and you that they should have a trust now that they have Sammy and Sarah even. So the question from Jacqueline was, so does the husband and wife, so the joint trust that the husband and wife have, is it just for the assets that were obtained in marriage? Like, or can they put their before pre-marriage assets in that joint trust as well? And I hope I'm asking your question appropriately, Jackie. And if I'm not, just let me know in the comments.
Yeah, that's a great question. So it would be, at that point, it would be up to Sue and Sam how they want to do that. If they want to have that joint trust and keep their separate things that they had coming into the marriage separately, they can do that. If they want to commingle and put everything in one joint trust, because essentially a trust is a document that says what assets you have. All right. The important part with the trust is actually funding it. That's taking those assets out of your individual name and putting them in the trust. If you do not fund the trust, all you have is an expensive piece of paper that says you have one. Okay, so if they choose to take their individual names off of all of those premarital assets as well as the assets that they've accumulated in the marriage thus far and put them on the trust, they can do that. If they choose not to, it's totally up to them. Remember, a trust is a private document that is driven by your wishes, desires, and goals. Yeah, that's a great question.
And so Margaret is giving us a scenario here. And so I'm just going to read that scenario to you. Margaret is a divorced mom of one son who is now 26 years old. His grandparents are deceased, and the only family that's close are two cousins that live in surrounding states, okay? And so she left the nursing profession 4 years ago, but her former hospital has asked her now to come back because of the whole pandemic that's going on, right? And so her son has asked her not to go because basically she's the only family he has left. But because, you know, because of age, because of how life typically works, she is expecting that she may possibly predecease him, right? And so she's getting her will, she's getting her power of attorney in place, and she's making a folder to include that's password protected so that she can give it to him to deal with if in the event something happens to her or upon her death. And so her question is, how should she approach him about telling him about the documents in the folder? Do you have recommendations on how to have that conversation?
That is a great question. My recommendation on how to have that conversation is to start those conversations early and have them often. It can never be too early to have the conversation, but it can certainly be too late. So approach it gingerly, approach it with care. Know that, you have to know his heart. You have to know everyone involved's heart and know how they're going to take things, and know that everyone is not going to be accepting of it. So many times we know we need to have those conversations, but we know the person on the receiving end of it is going to say, oh, I don't want to hear that. Okay, well, okay, well, when would be a good time for you to hear it? Just don't let it, I don't want to say die, but don't let it die, right? Have those conversations, have them early, have them often. I often have those conversations with families. I often have those conversations for families together with them. And oh, by the way, and I don't think Holly and I talked about this, but everybody that's on this workshop tonight is entitled to a complimentary initial consultation with me. So I will be reaching out to all of you, or Holly will be reaching out to everybody on here. But yes, some of these, some questions are like scenario and personal specific. So I in my initial consultations, I dissect all of those things. But to answer the question, it's easiest to have it early, have it often. Don't stray away from it. Don't allow them to stray away from the conversation, because the last thing you want is, let me find a piece of paper here. The last thing you want is to have your loved ones standing at the funeral. Imagine this is one of those napkins with the flowers on it, and you're eating the pound cake. I heard she didn't have a will. At that point, it's too late for the conversation. All right.
We don't want to be Aretha Franklin.
You don't want to be Aretha. Oh, thank you for mentioning her. So Aretha, before her 8-hour funeral was over, the state of Michigan already had her petition in probate court, because Aretha had 4 adult sons, one of whom was like Sammy. He is special needs. He's going to need to be cared for the rest of his life. And Aretha did not have a will in place. All right. Now, a year after she died, they found 3 handwritten wills. They had to stop everything and verify the validity of those wills. They didn't contradict each other, but they didn't say the same thing. Like, one of them said, I leave the piano to so-and-so. The other one said, I leave the couch to so-and-so. Well, there's 2 different things. They don't contradict, but the court had to stop everything and address that. So, even if you don't have Aretha Franklin assets, you have 2 pennies to rub together. You want to make sure that you know where those 2 pennies go.
Yeah, and Margaret, I will look up some other conversations. I know that in the personal finance community, there are some people, authors, I know this, that have written a book about crucial conversations and how to bring that topic up. And I actually see it as a beautiful thing, as a, hey, I am thinking ahead. I am planning for you. So while we don't want to talk about death, let's talk about the legacy that I plan to leave for you. And I am more than happy to go grab those resources and share it in the Facebook community, in the Master Playbook Facebook community. So you will have. All right, we have another.
Yeah, we talk about it in terms of life rather than in terms of death.
Absolutely, life and legacy, honey. Okay. All right. So Robin Mack asks, is the funding of a trust a one-time action?
It depends on if it's a revocable trust or an irrevocable trust. So with a revocable trust, you can move assets, you can change assets, you can sell things, you can take things out. And so at that point, whatever you have initially funded it with may not be what's in it in the end. And that's okay. With an irrevocable trust, however, you have to go through all kinds of hoops. And an irrevocable trust gets its own EIN number, so it's a standalone entity. And irrevocable trust is a lot of times used for generational wealth as well as Medicaid planning protection, because, and we could go on about that, would be a whole other seminar, but Medicaid often does, or not often, always does a 60-month look back at your assets. And if you had anything within 60 months that puts you over the minimum threshold, and it's about $2,500, then you don't qualify. So people take all those assets out of their name and put them in the trust, an irrevocable trust, so they still have all that stuff over here, but at the same time they qualify for Medicaid. So it is not necessarily a one and done thing, just like estate planning is not one and done. It's a fluid process. We revisit it when, again, the D's and the F's collide. And as you accumulate assets, as you sell assets, as your life and circumstances change, then you revisit that trust and see what else you want to put in it. As you buy assets, once the trust is in place, you just buy them outright in the name of the trust or as the trustee of your trust. And then there's nothing else to do to fund it. You do it as you go along.
Awesome. So we do have more questions. I'm going to run through these, but I do want to remind everyone that everyone on this call, we're going to share Shannon's information. She is offering a complimentary session, so you can give her all your personal scenarios and details to kind of talk through what you think is best. But the next question is from Andrea. She says, if beneficiaries are identified for investment accounts, do you have to mention those investments in the will or the trust?
You do not. However, if you have a trust in place, I many times encourage clients to take that named beneficiary off, and now you make the trust the beneficiary. And then you leave instructions in that trust to the trustee on how those funds are to be distributed. For instance, say somebody has a $1 million life insurance policy and they make the trust the beneficiary. Then they leave instructions. At my death, trustee, you are to, 1, pay for my funeral, 2, pay any remaining balance on a mortgage on my properties, 3, give each of my kids $1,000 or however you want to split it. And then you instruct what happens with the rest of it. So even if that means now you're giving it to the same beneficiaries that you had named, that's okay. But now it's being administered through the trust rather than the insurance company making that one distribution to that one named beneficiary. And also, if you put it in the trust, you don't have to worry about that named beneficiary predeceasing you. Because now, if you've named somebody who's no longer living, then that becomes an asset of your estate. And the state, again, can step in and get those proceeds rather than whoever you would have wanted to get them anyway.
Okay. How does a house with a mortgage work within a trust?
A house with a mortgage works within a trust because you change the deed from your individual name to the name of the trust or to you as trustee. And then you let your mortgage company know that now the property is part of a revocable trust. You cannot put it in an irrevocable trust if it still has a mortgage on it. So you put it in a revocable trust. You let the mortgage company know. They change some paperwork, but not all. You can still sell that home if you want to. You can rent it. You can do anything that you want to. You are still subject to paying that mortgage. And then you leave instructions on what you want to happen with it. If you want whoever gets it to have it free and clear and not pay a mortgage, then you set up the instructions that way, like I just talked about with the life insurance, for instance. Yep. Otherwise, they could potentially, if you leave it to somebody who can't assume that mortgage, then it risks being foreclosed on just like any other property if the mortgage isn't being paid.
Okay, and so going back when Robin asked the question about funding a trust being a one-time action, so just to clarify, when you say funding the trust, how does that really work? What does that really mean, since the trust can really be assets, can be physical things? Does a trust have to be funded with cash? And
no, a trust can be funded with assets that are forthcoming, like life insurance proceeds. Those aren't going to come until a person dies. But it's the process of taking your individual name off of that asset or the individual beneficiary's name off of that asset and now putting the trust name on it. So again, it's funding is the process of taking assets out of one name and putting them in another, and that other name is the trust.
Okay. And so as far as when you think about people who may be caring for children and elderly parents, so they're in that sandwich. What are your recommendations on how they should allocate their assets in the event that they pass, but they have adult children who survive and they have elderly parents who survive? Do you have any recommendations on how they should consider allocating those assets?
Consider it gingerly. You have to look at your family dynamic. There is not one and done key answer to everyone, because the estate plan, it's customized. It's customized to your family, to your situation, to your generation. And so looking at the finances and how they are set up and how you manage things today can be key to how you want to plan for tomorrow. And again, it's not a one-time thing, it's fluid. So if today you split them evenly between mom and dad and children, okay. If tomorrow mom and dad have passed away, now you revisit it and reallocate it to the children or not, right? It's all in your choice, in your decision, in how you would want your legacy to look. So there's really not a stockpile answer for that. It really is, depends on the situation and what you want it to look like in the end.
Yep. Now, is there a time frame to revisit your will and power of attorney?
There is a time frame. No, well, there's not a time frame per se. I like to use the rule of once a year. This is what I do with my clients anyway. Once a year, I revisit. Hey, how you doing? Has anything changed? Right? And sometimes rules change, laws change. So to keep up with your plan being consistent with the laws and the rules and your goals, I revisit once a year. Also, time frame wise, anytime those 4 Ds and those 5 Fs collide, revisit your plan.
Love it. And so our final question is, how do you go about finding someone to help with all of this? So glad you are here.
Fantastic question.
Yes.
So
this person specifically lives in New York. She's been trying to get these documents done for years, but feel lost trying to find the right person to help her.
I get that. And so I am licensed here in Georgia. I oftentimes partner with people in other states who do the same thing that I do and who are as passionate about it as I am. I never partner with somebody that's not passionate about it because they won't do a quality job for you. So I often partner with people in other states to do the work. I have somebody in New York that I connected with and love her. She's great. She's very passionate, much like myself. And so just having the conversation, starting the conversation with somebody where you are, and if they cannot handle it in your jurisdiction, asking if they can recommend or refer somebody else in the proper jurisdiction.
This is awesome. This has been so informative. And guys, the reason I wanted Shannon to come on is because everyone needs this. Again, you don't have to be rich. You don't have to be wealthy. If you have anything at all that you want to make sure goes to the right person or is protected, then you need to create an estate plan. And especially in this time of COVID, I said it at the beginning, but people unfortunately are passing far sooner than they would expect because this COVID-19 is so unpredictable. And I don't want to see another one of us. I don't want to see another one of us be not prepared. It's bad enough that you're in there by yourself. If you happen to be infected with the virus and have to go to the hospital, you need someone there who can advocate on your behalf, someone who can make decisions for you when you can't speak up on your own. And so this is so critical. So please just come on here and listen and watch the replay. I want you to do those things, but I want you to be inspired to take action. What all of this is about. And so to make sure that you guys take action, go ahead and write down Shannon's information. Write her email down, write down her phone numbers, write down her website, because I want you guys to take action. Shannon, before this, I had already referred you to a young lady, and hopefully you guys connected, but I think I had the wrong number back then. I had your old email and website. So now she has the information because she's on the call tonight asking questions. So happy to do that. And I really this is in the pillar of building wealth.
Yes.
What is the use of building wealth? What is the use of growing a business? What is the use of attaining all the money and material possessions if we don't have someone to pass it along to? And so these things are going to put those things in place so we can start closing the wealth gap that specifically is present in Black and Brown communities. And so we want to stop it. We have the information. We have people who look like us who can understand the situation, can understand the dynamics.
Yeah.
Instead of, certain conversations where we where we talking about how much weight you gained at family reunions. We need to talk about, let's talk about this estate planning.
Yes.
Have you done your will? Let's talk about it.
Mm-hmm.
I hope this was helpful to you all. This was so beneficial. I just want to thank you so much, Shannon. Again, the replay will be available for those who are members of the Master Playbook Facebook community. So if you are not a part of our community, it's all about helping you keep your financial goals, your financial plans a top priority throughout the year. And a lot of our trainings, teachings, a lot of the things I post are going to be in 3 pillars. They're going to be helping you ditch debt, save with purpose, and build wealth. And so this is all about not only building wealth, but passing it on to future generations. So again, thank you so much, Shannon. We have enjoyed.
Thank you.
You all will receive an email from me, just again, encouraging you guys to have a conversation with Shannon. I don't care if you live out of state. We're going to want you to have a conversation with Shannon to see how she may be able to help or guide you in the right direction to take action on this.
Right. Take action. Don't be a passive participant. Take action.
Right.
Yeah.
That's right.
Yeah. So thank you, Holly, for having me.
No, you are so welcome. Now, one thing you don't have on here are any social media. Are you actively on social media?
I am. I just didn't put it on here.
All right.
Yeah. It's at the same Legacy Legal ATL.
Perfect. Well,
yeah.
Here you go. Everyone, thank you again for joining us, and I look forward to seeing you next time.
Thanks, everybody.